I think we'll get started now. Good morning, everyone. Thank you very much for joining us this morning for this webinar, which we've titled Roadmap to the EU. We'd like to thank especially staff and representatives from the European Parliament who are joining this event, as well as other participants joining us from Albania and across Europe this morning. Just to let everyone know, first of all, this event is being recorded and we are intending it to be made public. And also, we also have a simultaneous Albanian language interpretation for this event. So for those of you who are unfamiliar with the system, if you go to the bottom panel, there is a button for interpretation, and you can set that to either English or Albanian, depending on your preferences. So my name is Bruno, and I am Fair Trials Legal Director for its office in London. Although I'm based in the UK, the subject of our discussion today is the EU and Albania's accession to it. I assure you that the irony of my hosting this event from England isn't lost on me. But I am speaking today on behalf of my colleagues in Brussels, whose invaluable work oversees criminal justice developments in the EU. By way of background, Albania is currently on course to becoming the EU's new 28th member state. It became an official candidate country in 2014, and in March last year, accession negotiations between the EU and Albania officially began. Becoming a member of the EU is, of course, much more than a political, legal, or administrative process. It's about joining a close-knit family of nations with shared values. It's an expression of how a country and its people see themselves in the world, how they envisage their futures, and how they identify. But of course, on a much more technical or even boring level, a major aspect of joining the EU is a legal one. Albania, like all other countries that came before it, have to ensure that its laws comply with the EU standards. Often the primary focus of this process, as far as the laws are concerned, has been around laws regulating the trade of goods and services, as well as the labor market. Criminal justice hasn't always featured prominently. In a way, this isn't all that surprising. The EU is not often associated as a source of criminal law. And it's only really in the last 10 years or so that it has actively legislated to set minimum standards relating to criminal procedure under what's known as the Procedural Rights Directives or the Roadmap Directives. But Albania's accession process is a little bit different from other countries that came before it, in that it's joining the EU where there is already a body of legal standards relating to criminal justice. And also quite important is the fact that, also quite relevant is the fact that it's also joining the EU at a time where there is growing recognition that the rule of law and fundamental rights are under threat in several EU member states. So it makes sense for the EU to pay special attention to Albania's criminal justice system and its adherence to human rights standards more generally during negotiations. And this is something that the EU is already doing. The administration of justice, human rights, and criminal justice have all been identified as key priority areas for Albania's accession to the EU. So Fair Trials has teamed up with Res Publica and civil rights defenders to assist and inform this process. We've been working with local experts in Albania, including NGOs and practicing lawyers. We've studied the extent to which criminal justice standards in Albania comply with EU laws, but not just on paper, but also in practice, because there is usually a very wide gap between law and reality. we believe that this exercise not only indicates the progress in joining the EU, it's also a reflection of the general state and health of the criminal justice system, the extent to which it respects basic human rights principles, and the extent to which it's capable of delivering fair and effective justice. The event today marks the launch of the fruits of these efforts. Our report, titled Roadmap to the EU, same as the name of this event, is available in English and Albanian, and you can download that from our website if you haven't done so already. In this report, we carried out a detailed review of Albanian laws, policies, and practices, and compared them with existing EU standards that are contained in the Procedural Rights Directives, or the Roadmap Directives. Here, we identified major areas for improvement. In other words, things that the EU needs to look out for when assessing Albania's criminal justice system, as well as practical recommendations that the Albanian government and its competent authorities can and should adopt to further progress of reforms. Today, we're bringing together experts from Albania and from across Europe to discuss these findings and to talk more generally what improvements are needed in Albania's criminal justice system and what the risks and implications are for failing to adopt those improvements. So on our panel today, I'm just going to start introducing the panelists. So on our panel today, we have first and foremost, Laure Baudrier-Gerard, the Legal Director of Fair Trials Brussels office. Laure oversees Fair Trials work in the EU, monitoring and informing criminal justice developments in the region. Then we have Goran Militic from Civil Rights Defenders, who partnered with us on this project. Goran is the Director for Europe and Deputy Global Program Director at Civil Rights Defenders. He's been active with the organization's human rights work in the Western Balkans since 2004. Next, we have Irene Dula. She is a legal researcher and attorney with 15 years experience from Albania. She carried out the research for this report on behalf of Res Publica. Besides practice and research, she also writes and speaks extensively on legal affairs. After her, we'll have Jordan Dachi. He is a lawyer at Dachi & Associates in Tirana, which is a firm that specializes in criminal and civil litigation work before Albanian and international courts. Jordan is also a member of LEAP, a network of legal experts coordinated by Fair Trials. And finally, we have Christophe Marshall, a partner at Jus Kogan's law firm in Brussels. He's a specialist criminal justice practitioner with extensive experience in human rights, extradition, and terrorism cases. Before we get started on our discussion today, I'd like to invite everyone joining us today to participate as actively and interactively as possible. The Q&A function has been activated, so please use this to ask any questions you might have for any of the panelists as they are speaking, and I will relay those questions to them. If you want to be even more engaged, you can put up your hand, and I might give you the permission to speak as the host of this webinar. So let's get started. So I wanted to, first of all, turn to Laure. Laure, I was wondering if you could go into a little bit more detail about what these EU procedural rights or roadmap directives are, and why it's important for member states to the EU, new member states to the EU, to be implementing these standards and the directives. I mean, we know, of course, that they are part of the package of laws that need to be implemented in order for a country to join the EU. But is there like a deeper purpose of adopting these standards?
Thank you, Bruno, for the question, and hi to everyone. So yes, the directives, so these procedural safeguard directives, meet key policy objectives for the EU. And I think before going into more detail, it's important here to take a step back, because we need to avoid reducing them to a procedural technical box that needs to be ticked, even a boring box, as Bruno put it, because EU membership obviously involves the ability of persons to move freely across borders without having internal borders between the different member states. And especially prompted by the attacks in the 9/11 attacks, there was very much a focus on problems that removing borders meant in terms of criminality, in terms of opportunities for cross-border crime. And that's how the EU adopted the European arrest warrant very quickly after the events of 9/11. And they adopted the EAW on the basis of an extension of this principle of mutual recognition that Bruno mentioned as well, that really stems from this internal market, from promoting the free movement of goods and services. That's this principle of mutual recognition that was extended and implemented into the field of criminal justice. But there are obviously key differences here. In the internal market, the concept of mutual recognition presupposes that legal standards between two member states concerned are equivalent. So the country of origin and the country of destination are more or less the same. And if it's not the case, then member states could refuse recognition by relying on certain justifications, like the protection of ordre public, the public order. But with the EAW, this has implications on fundamental rights and national sovereignty. And it was very interesting to see that the European Parliament a few days ago adopted a resolution regarding the European arrest warrant and recognizes this, recognizes that mutual recognition was just extended to the EAW, but that it has many more implications than exchanging goods and services. Obviously, it concerns fundamental freedoms and rights of individuals. So states quickly faced the realization that cooperation through extradition on its own, based on mutual recognition, was not adequate. And there was a need for common legal standards to reduce legal differences between member states. And so to facilitate cross-border cooperation, there was a drive towards harmonizing both substantive criminal laws, so for instance, concepts of corruption and terrorism, but also procedural criminal law. And in particular, to ensure that all member states had a shared common minimum standards when it comes to procedural safeguards. And this is very much a recognition of the policy goal of the EU, that it's not just about tackling criminality, which arises as an unwelcome side effect or as a risk, an inevitable risk of a European area without borders. It becomes clear, because it's part of a policy objective, to promote the values of the EU, which are set out in the treaties. So the adoption of these common standards, the harmonization of criminal procedural safeguards, is an expression of common values of the member states, and in particular, fundamental rights and rule of law, which, as Bruno said, are under threat in several member states, meaning that these safeguards, these standards, are more important than ever to promote progress and avoid backsliding on rights. And so the Treaty of Lisbon, which was later adopted, established that the EU has to constitute an area of freedom, security, justice, and part of that common area is that fundamental rights are fundamentally respected. And that's why the directives are so important, so much more important than a tick box exercise, because security and human rights go hand in hand. They're not opposed. And so we have these 6 procedural safeguards that were adopted progressively over the past few years, from the right to interpretation and translation for suspects and accused persons in criminal proceedings, the right to information about your rights, but also information in the sense of access to the case file that the state has against you, access to a lawyer during the early stages of the criminal proceedings, as well as the right to the presumption of innocence and the right to legal aid, as well as a specific directive on the right of young juveniles in criminal proceedings. And now we've got we've got a series of EU measures in criminal justice. We've got these procedural safeguards, these 6 directives that I went through, as well as a recommendation, which is not binding, but also very important, on the rights of vulnerable suspects. These set minimal common rules for all member states. We also have legislation harmonizing substantive criminal law, and then we have more and more cross-border cooperation instruments. The EAW, of course, on extradition, but also alternatives to extradition, such as supervision measures, and also the exchange cross-border of evidence. But so we have a whole bunch of different measures now in the EU, and new and existing member states need to ensure that there's coherence. We need to focus now on coherence of all these different instruments to ensure that we keep in mind the fundamental policy objective, which is to give effect to the common values of the EU, which are essentially fundamental rights and rule of law. So that's how I would like to kick off the discussion. Thank you.
Thanks very much, Laura, for really helpfully explaining to us kind of the very reasons why these directives exist in the first place, and the putting into context that the idea of implementing these standards isn't just a matter of just an administrative process of updating laws in order to join the EU. There are kind of real implications for what happens once the country joins the EU for having not implemented these standards. But we'll come back to that, I think, a little bit later in terms of kind of, what those challenges look like in practice. But I wanted to, first of all, move to Goran, and just kind of coming back to the question of kind of, the accession process for Albania. I mentioned earlier that kind of, the EU has identified things like the rule of law and fundamental rights and justice as priority issues for Albania for its accession to the EU. So from your experience of working in the region and in Albania in particular, looking at it kind of more holistically, how much progress do you think the country has made since the accession progress began? And what do you recognize as the main areas still in need of improvement?
Well, I mean, the story about rule of law in the Balkan region is like a story of this glass of water. Is it half full or half empty? Depends how you see it. So this is the situation with not only rule of law, let's say with the entire human rights, implementation of human rights standards in the Western Balkan region. So some people see it as empty, or some of them see more as a full, but the situation is quite simple. Are there any progress? Yes. Is this progress good enough, or is it reforms are happening fast enough? Definitely no. I mean, Balkan countries has enough capacities, and Albania, of course, has enough capacities to have reforms much faster and to have changes in the society much faster and to deliver changes much faster. So we cannot be satisfied with either pace and the second implementation of those adopted legislation. So significant progress is definitely made in Albania when it comes to adoption of legislation, when it comes to adoption of some bylaws, even some measures and so on. Of course, adoption of that legislation was not as fast as we would like to see it. It was always connected to politics. It was always connected to some internal dynamics when it comes to society. Elections are quite frequent in all Balkan countries. So, I mean, situation is not...
Mr. Goran, please, a little bit slower.
Satisfied when it comes to so many different laws that are adopted in relation to rule of law, but also in relation to some other, let's say, some other areas that exist. I must say always that access to justice and rule of law are always connected to some other part, like media legislation or anti-discrimination legislation, some substantial laws that are important for the functioning of society. And I think that we have that in Albania. I mean, not everything is in place, but we can say that a lot of things are in place already. The main component, of course, of the implementation of the new system and reforms were vetting process. And vetting process was not that simple, but let's say as a precondition is completed in a way, and let's say people think that it works and that it's done somehow. So process starting three years ago, I mean, like let's say like that, and it should bring stability to the justice system once when it's finished. So a lot of things need to be done that are related to side effects of the vetting process. I mean, and a fully function the problem of a fully function constitutional and high court were a problem for a long time. Now they are partly function from 2020 and so on. So despite these positive developments, and we see positive developments are most related to adoption of some legislation and then partly implemented, the legislation that is partly implemented in practice, a lot of things need to be done. Some judges need to be still need to be elected, and then we have the story of the backlog of cases. That is a problem not everywhere in the Balkan, but let's say in majority of Balkan countries, it's definitely a problem. As far as I know, there is 35,000 cases in before appeal court. And then this will create backlog cases before other courts. So this is the situation. Everything is interconnected, and our attempts to see only legislation and then not to look into the implementation, or to see only vetting process as something most important, and not to look into some laws that maybe need to be adopted yet, or some implementation when it comes to access to justice, or other rights that citizens might have before the court are not good enough. I think we should see the whole picture. The entire society, we should see dynamics that exist in Albania and many more. So in order to assess, we need to have the whole picture. Also, part of that picture that is very important and that we are forgetting sometimes, because we are too much focused into EU. We are talking about, okay, EU accession. We are so dramatically, and of course, EU is the driving force in the region and in Albania, and that's very nice. But all our countries in the region are members of Council of Europe. And Council, okay, Kosovo is not member of Council of Europe yet, but still for Kosovo, all judgments are valid. All judgments of European Court are valid. The interpretation of European Convention is valid for Kosovo even. So even for Tirana, is it in Albania or Serbia, Macedonia or Bosnia, the standards are the same, like in Sweden, UK, Belgium, Norway, whatever. So we have absolutely the same standards. And we should not wait some EU to come and to tell us, okay, how exactly we need to, have fair trial standards or implement fair trial standards, what it means independence of judiciary. No, we have that. Everything is really written and very well explained. Judgments of European Court are very, very long, and you just need to sit down and read. And we really invest a lot of time in translation of those judgments, and Council of Europe did it. So there is a lot of resources in order to improve and fair trial standards in Albania or any other Balkan countries. So we don't need to wait EU accession in order to improve some things, and that's why we need to invest more in capacities of local lawyers wherever they sit, in court or civil society.
Thanks very much, Goran. And I think kind of the last point that you highlighted is particularly important, in the sense that kind of we should really be from an Albanian perspective, probably, we should really be looking at this as an opportunity to further the progress of human rights in the country. Not just kind of looking at it as a kind of a process that needs to be satisfied, because one of the main things about the directives that we're talking about today is that they're meant to be in many ways like a reiteration of the standards that exist in under the Convention on Human Rights, and also the jurisprudence of the Court of Human Rights, as well as kind of adding bits to those standards as well. So I think kind of that the point that you made is highly relevant, in the sense that this should be happening independent of the accession process, really. But the accession process is something that's an important driver of what should be happening. Turning now to Iran, let's be a little bit more specific to criminal justice reform. because, you know, in Albania, I know that there have been quite a few changes as part of the accession process to criminal justice procedures. What's your overall assessment of these recent criminal justice reforms in Albania? And could you give an opinion as to how impactful you think they've been?
Bruno.
Yes, Bruno.
Can I switch to be the first one as we talked in the beginning? Because otherwise I have to leave in a few minutes. I have a court hearing. I have no way to escape it.
Sorry, I was going to make sure that we've finished for you before 11:30, but I was going to bring you in kind of after a brief intervention from Iran and then go back to Iran after you've spoken. Is that okay?
Okay.
Yes,
okay.
it's okay.
Iran, please go ahead.
So, thank you, Bruno. Ndryshimet në legislacionin shqiptar në vitet e fundit edhe në kuadër të reformës në drejtësi, në fakt kanë mundësuar njësimin
Thank you, Bruno. Actually, the changes have led to minimal standards for the EU, considering also the directives developed by fair trials as well. These changes actually, at first sight, seem to have improved the procedural rights of defendants and the suspected persons, but considering laws, practice, and policies from a closer point of view, there are actually suspicions regarding the implementation in practice of the roadmap and the directives. So the challenges is to go beyond the legislative changes and to implement the directives in practice. These challenges can be resolved by involving different partners. Of course, the methods change from legislation review, not only at the legislative level, but also through administrative acts and measures, which would be more flexible. But also the activity of civil society, but also lawyers who are defendants and kind of supervise the implementation of these practices regarding suspected persons and defendants. That's all I can say in such a brief time, and to see where we are in the justice reform in this regard.
Thanks very much. Thanks very much, Iran. So I'll turn to you, Jordan. So kind of like, you know, as Iran just very briefly mentioned just now, you know, there have been considerable changes to, or some changes to criminal justice laws and policies in Albania in recent years, much of which has been triggered by the accession process. But, you know, from a practicing lawyer's perspective, I know that it's still relatively early days, I suppose. Do you think these changes have resulted in real changes to practice? And kind of what do you think are the most notable changes, to the extent that there have been notable changes at all?
Well, as part of justice reform done in 2016.
Për sa I përket reformës në drejtësi, shumë ligje kanë ndryshuar.
Sorry, can I just interrupt? Sorry,
Ne kemi arritur
using the wrong channel for interpretation. If you could switch, thank you. I'm hearing Albanian.
Let me. I don't have it here.
No, it's not. It's not for you, Jordan. I was just speaking with the interpreter. Sorry. Yeah, but do carry on.
Okay.
Yeah.
So basically, from 2016, a lot of amendments were done to our legislation, and in 2017, to the Criminal Procedure Code. And those changes, basically, most of them were a step backward other than forward in regards to defense guarantees and also to the defendant rights. For example, we made a step backward in regards to the pre-trial detention hearing. Before, it was used to have a hearing with the participation of all parties. Now, only the court seated in chamber will decide for trial, for pre-trial arrest order or whatever. So this is something that I consider it is not an improvement, rather than something bad for our criminal justice. On the other hand, many of these changes have resulted into a lack of functional Supreme Court. So we don't have a Supreme Court functional in last 3 years, and I don't expect to have a full functional Supreme Court even in this year. We didn't have a fully functional constitutional court until a few days ago for the last 3 years. So basically, when you challenge, for example, a pre-trial detention, everything is closed within the appellate courts, and there is no way that you can submit a recourse before the Supreme Court or the Constitutional Court for further review. At the same time, you cannot go to the Strasbourg without exhausting our national remedies, which actually de facto right now they don't exist. So those changes have introduced major impact to our criminal justice system, including also the COVID-19. It's also somehow there is no more any public hearing, although in some court hearings, for example, we have a lot of space where few people can sit, still can be respected the public hearing principle. But the judges now, they just take it for easy, so, and for granted, there is no public hearing at all, and there is no alternative broadcasting. So no media participants can be part of the trial, no one, just the defense lawyer and the defendant. And sometimes even the defendant is missing. For example, I had a case when the defendant was a COVID suspected person, and the pre-trial was done without his participation at all. I didn't have even the chance to talk, even I as a defense lawyer, but also the court at all. So he was not existing, although the court decided for him and put him in jail. So those practical issues have came out after the introduction of new amendments to the Criminal Procedure Code. Now there is a new amendment undergoing, which I think it's going to make the situation worse from some perspectives as well. But regarding the topic that we are talking about, regarding the European integration, we haven't started the negotiation yet, so it's not open, the negotiation yet. We haven't, we just are a candidate country so far. Because of the Bundestag conditions, there were like 15 conditions which were not met, and also from the Dutch, also they requested from us some other requests, and I think, to be fair, Albania failed to fulfill this criteria before being ready to open the negotiations. So other changes were introduced. For example, we introduced for the first time what we call now, although it's a kind of mix between Italian model and our, it's a pre-trial hearing judge. So we have a pre-investigation judge which deals with the pre-investigation stage. And now we have also the pre-trial hearing judge, which is something very unique, but that has produced a lot of issues in practice and also in regards to defendant rights as well. We had just in last days, we had a decision from the newly established Constitutional Court refusing, for example, that when somebody was tried in absentia, the judge who sent for constitutional revision of the article of the Criminal Procedure Code was seeking the unconstitutionality of reviewing the request for revision in absentia again. So you were claiming that you have been tried in absentia, and then your request for reviewing of your final judgment delivered in absentia is still done in absentia. So I think there is a lot of mismatching between what we have introduced with the new amendments done in our legislation and what the directives provide as a framework, which I consider that will somehow serve as a key tool to improve our national legislation regarding criminal justice. But the approximation process of this directives with our national laws is far away. Most of the drafts that have been prepared so far or have been approved, or even those who are undergoing right now, they are still far away from the standards that these directives provide for. For example, in regards to now our defendants stay in glass rooms now, and it is impossible to talk with a defendant, even to exchange letters or messages as a defense lawyer, because they are like in aquarium, like fishes. And this is done on behalf of the security, but this is something that it changes what it is defined in law, that a defendant should be tried being free, although now it is not free, basically. So this is just an example how the law changes when it comes to practice. We used to have bars before, and now we changed the bars with glass, which is even worse, to my understanding. Other issues have with the pre-trial, it's still one of the most serious issues that we have. In almost 95, even more than 95 sometimes of cases, pre-trial detention is ordered. So no way that somebody can have a different security measure, like a home arrest or etc. It's very rare. And also alternatives to imprisonment are very rarely applied. And this is also very serious because our prison population, 44% are pre-trial detention people. And those 90, because we have our innocence rate is 2.5, which means that 75% of them, no, only 2.5% will go out. The rest will be remaining in prison. And this shows the severity of the situation regarding the alternatives to imprisonment, to pre-trial detention. Many international reports and studies says that the appellate courts, they just serve as rubber stamping the first instant courts in regarding pre-trial, or also right now, for example, there is no Supreme Court, and the delay of reviewing a case, it's a nightmare. Before, for example, at the appellate court of Tirana, a case would wait from 6 months, the best, and the worst, like 1.5 years, something to be reviewed. Now this time it's at least 4 or 5 years. Why? Because from 34 judges, there are only 10 judges left now. Because through vetting process. But first things is related with the fact that although we are kicking out the judges and prosecutors who are presumed to be corrupted or unprofessional, there is no legal mechanism that replies them in real time. And our system will take years to replace them. This is a little bit more easier for first instance court judges, but when it comes to appellate court judges, when they have to be serving to have experience in bench for many years, then we will not have judges at all. And this is the situation. So regardless what we have in place in terms of legal framework, I think we are very far away from European standards, and we are daily violating the European Convention of Human Rights for many aspects in regards to criminal justice.
Jordan, I think we lost you, but I'm assuming that that was more or less what you wanted to say. So assuming that we can't reestablish connection with Jordan, I'm gonna just kind of come back to Iran, but I think kind of Jordan mentioned kind of some really interesting things there, kind of one of which was kind of the reiteration of the fact that there is actually quite often a very big gap between law and practice.
It's power is going off and on. That's why sometimes I'm having connection issues.
Oh, okay. So we got you back now, Jordan. So I was just kind of highlighting kind of what you said in terms of the reiteration of the point around the big gap between law and practice in criminal justice systems, and also it also highlighted that we often talk about this as in that very narrow lens of EU law and the directives, but actually, of course, the problem is far wider than just the narrow scope of these directives. As useful as they are limited in scope, and there's a kind of, you know, I suppose a gigantic elephant in the room when it comes to legislating the EU's legislation of minimum standards, and that probably the single biggest problem that we have in Europe with this criminal justice system, pre-trial detention, I think, hasn't been addressed, and no country really seems to have got this right in any event. So, you know, there's some really kind of, you know, urgent action that needs to be taken in that regard, which you know, perhaps the EU accession process won't necessarily help with, which is a real shame. Just coming back to the question of the gap between kind of law and practice, kind of you gave examples of things like kind of, you know, how the presumption of innocence is violated during court proceedings through the use of, you know, glass cages, as well as kind of, you know, how trials in absentia are dealt with, and so on. I just I just wanted to get from you kind of, you know, what you see as the fixes to these kinds of problems. I mean, surely it's not just a matter of, you know, updating or kind of making further amendments to the laws, or is that the right answer?
Well, I think there is a lot of room for legal clarifications and new norms that will correct some issues regarding, for example, the cages. And I think those things can be easily fixed as long as there is a will for addressing them. We have also other issues, for example, like ex officio lawyers are appointed basically by a list provided by our bar association, but none of the judges or prosecutors are respecting the list. So they are picking up those who serve them as best as they can, sometimes even without being present in some action that they sign up. So the effective defense is many times missing. And this is also because of the court, because the court is not, let's say, serious enough and does not pay the right attention in regards to securing the right to an effective defense to every defendant. And the other issue that we have in practice that we have a very long period of pre-trial investigation stage. It can go up to 3 years, and sometimes this can be overpassed because when they register the names of the persons, when they initiate an investigation, they do it without a name. So basically they are using this kind of investigation having no name as an excuse for having as much time as they want to for the course of investigation. Although we have a 3 years limit, which is, I think, the longest among the European countries, and it can be extended under specific conditions provided in law, none of the judges is really paying attention to criteria that the law sets in regards to extending investigation timelines, and also they are not paying attention when the prosecutors register an investigation without a name, although they have the name, and sometimes they use the name of the person 2 or 3 times within the same decision that they order the opening of investigation, and still they do it without a name at the end. So those are issues that not only requires laws, but also requires a new mentality among judges, especially. But as I told you, we are not having judges at all.
Sorry, we lost you there again.
Mechanism that replies that. So judges now, they have most of judges, the average caseload is more than 800 cases. Can just imagine 800 cases, the average, or even sometimes they have more. Only 365 days a year has. So basically, can you imagine what we expect from them? like in terms of quality of reasoning. Basically, most of our judgments are not reasoned, or they are partially reasoned. They fail to address key claims submitted by the defense or by parties in other processes. So there is a huge, let's say, human resources issue that is also another reasons why the system fails to secure some of the rights. So we are not enough only having laws, but we need to have also financial support, administrative supports, and of course, to have enough judges and prosecutors. I think that it's even better to leave aside a road, unpaved one, and have more judges on bench so that people can have justice in due time, rather than do a road, construct a road, and have this mess that we have in practice. And the thing that I'm really concerned is that all the European community, especially also EU representatives, although we all support the vetting process, trying to justify what they have done in regard to vetting. They are justifying even the missing of judges. They are justifying the delay. So everything is done for the good cause, the vetting. So if you are in prison, stay there because we are doing the justice reform. So why you are claiming such things? There is a good cause. There is a major cause that doesn't give you right to pretend these things. And I think those are not things that can fit to a rule of law state. And I think Albania is not a rule of law state. It's a really failed rule of law state at this moment.
That is an extremely damning assessment.
Well, tell me, is a rule of law state a state that doesn't have a constitutional court for 3 years, that doesn't have a Supreme Court for the last 3 years, and is not going to have even for more years? It's very basic. Can you consider a state a rule of law state when it takes 15 years until you have a final verdict in your hand? I don't think so. The rest is rhetoric. The rest is politics. I don't care. I'm just care. I have a law. I have the standards. I have the people in prison. The rest is just politics. If you want to do politics, we can say, okay, we are doing the justice reform. That's why we have to wait, and we have to wait and wait. But a person in prison doesn't care about this. And it doesn't have to care because any one of us can be at a certain point under certain circumstances in the same place. So we have to be concerned not only for those in prison, for everybody in society.
I couldn't agree with you more, Jordan, actually. It's, I think, kind of what's usually left out in this process of reforms or, amendments to laws and things like that is kind of, there's a certain lack of thinking, certainly about the broader structural issues that prevent effective kind of, implementation of, fair trial rights standards, or just basic standards on kind of effective administration of justice. And that's something that gets left out in conversations quite often, as is this question, the recognition that at the end of the day, it is about the defendant. It's not about, politics. It's not about kind of, showing that you're making changes or anything. It's, as you said, kind of the defendant sitting in prison doesn't really care about that. And it doesn't, and it shouldn't matter, what the politics of it is. It's, it's really, a question really is about, the main question should be about the rights of the defense and how the defendant experiences the criminal justice system. But I'm going to let you go now, Jordan, because you said that you've got a court hearing to go to. So thanks very much for
thank you
for your intervention today. Just a quick reminder to other people joining the webinar today that the Q&A function is live. So to the extent that you have any questions for the participants, please do send those questions through to the Q&A box. But I'm going to turn next to Irene and kind of ask more or less the same question that I asked Jordan, which is kind of like, from the research from the research that you did for Res Publica, what did you kind of establish as the most serious gaps between kind of EU standards and local laws?
Po mendoj që megjithëse koha është e shkurtër.
I'm thinking as we are short of time to stop by bullet points, pointing to the recommendations and the findings related to them. In general, I would like to pinpoint that that we see that the directives have been transformed into the legislation and everything is guaranteed in the law. However, many challenges, we are facing many challenges, and if we want to have an effective standards of the directives, starting with the first directive, translation and interpretation directive, first of all, is that interpretation and translation should be of a certain standard and which should be a basis to contradict the evidence if translation interpretation fails to reach. Second, the interpreters should be specialized experts and should be trained in legal languages, legal language trainings, which makes it important to have an effective procedural defense. Third, we need to have a self-regulatory body to get to know these methods and to regulate these professions in order to have a much better translation. The legal interpretation and translation we should make a difference standing between these two terms, and at the same time we need to have different skills specified for each of them in order for the defendant to pretend for the interpretation. This interpretation should be held free of charge, because by the end of the decision, when the verdict is taken, the party losing the verdict needs to pay the charge of the interpretation. So let's move on to the second directive. First of all, we should limit the prosecution body without informing them of their status as a defendant, and at the same time excluding the proof and evidence to be received. Also, secondly, the defendants should be much more able to be provided the possibility to defend himself and to be the respective experts, legal experts, should be able to explain to the defendant in a much simpler language everything, and the defendant should get acquainted earlier regarding their detention, which is one of the problems in our bodies. Also, rejecting the access to information should be a secondary issue. Closing to the third directive, let's move on to the access to a lawyer and defense. The judge, the courts, and also prosecution should be able that in most of the parts, the prosecutions really do not provide the room for the relationship lawyer and defendant, and which brings a limitation of the relation between both of them. And at the same time, there should be a rotation of lawyers in the Albanian legislation, and lawyers should be given the possibility to be able to determine the respective lawyers, but still we do not have a serious monitoring of this choice. We should provide an effective scheme of the lawyers as well in the first stages. As well, we need to provide the necessary measures that this rotation, the lawyer rotation, be able to cover the financial fees, which especially during the trials in Albania, the defendant or the one losing his defense is obliged to pay the fee. It has been a little bit. Our recommendation is to make this much more simple. That who is going to benefit from a certain scheme in order for in order for the defendant to face the financial costs, and not to discriminate the persons in charge or the suspects. That is what I wanted to say. Just a little short.
Thanks very much, Irene. Kind of one of the things that surprised me and kind of concerned me the most from the research that you did was the kind of what you said kind of towards the end of your intervention just now, which is around this cost regime for legal aid, which kind of essentially means that it's the way that I interpreted the research, was that kind of almost anyone, regardless of their ability to pay for a lawyer, might have to pay back some of the costs of their defense if they lose if they lose if they lose their case. And what really bothered me the most was that kind of, it was because it was in cases of mandatory defense that the costs of defense representation could be recovered by the state. That meant that, the most vulnerable people who were always entitled to mandatory defense, including individuals with disabilities and minors, would inevitably face that situation where they might have to pay back the cost of legal representation, which seems very, very unfair and almost inhumane. So, would you like to kind of elaborate on that and just kind of also correct me if I understood this wrong?
Jo, ju e keni kuptuar drejt, është tamam.
No, you got it right. Actually, this is the issue. Actually, Respublika was involved in drafting the law for the provision of free legal aid. That is why it's a law that I know about closely when this draft was developed, and we've always had the problem of urgency in adopting legislation, and actually we've made the recommendation at the time, and we noted that this would be a problem in practice, as it is, but it was never reflected in the law. And at the same time, when the justice reform was adopted and when the changes were made in the criminal procedure code, because that's the second scheme. When I talk about scheme, we have procedure and a code, a procedural code and a code, and in this procedure code, again, does not have a provision, or they did not think about this problem that would come about. So we recognize the problem, but it is not addressed procedurally. So the practice is that at the end of the trial, whoever loses the trial is charged with the expenses, whether they are incapable of paying, whether vulnerable groups or disabled, whether they cannot afford it, or whether it's so it has not been addressed in the law or in practice.
Thanks very much, Irene. I'm conscious of the time and the need to get things moving. And I'm also conscious of the fact that Christophe hasn't spoken so far. So I want to kind of turn to Christophe now. One of the kind of main things that Law said earlier on during the discussions was that, you know, one of the main reasons for the implementation of the directives is to facilitate effective criminal justice cooperation between member states, and, you know, and the EAW is the primary example of how member states cooperate in terms of criminal justice within the European Union. You're a criminal and extradition practitioner in the EU, and you have dealt with 1 or 2 cases of extradition to Albania. And I just wanted to get a sense from you, from your own experience, what you know, what you found to be the main issues affecting extraditions to Albania.
Okay, thank you very much, Bruno, and hi everyone. I'm very happy to be in this panel for fair trials and the partners in this project, which is very important because I think it's really touching a key issue in cooperation that we also see within the EU. It's not only a problem that would appear with Albania, but it's also a problem, this high level of confidence that also touching EU member states in their relationships. Now, the situation of Albania, as all the panelists have said now, Goran has been talking about the vetting process. What is it? It just shows that there is a systemic or a big problem of corruption in Albania, in the judicial system. That's what it shows. It's just the acknowledgement of that. Iran has shown that there are a lot of problems related to the laws and to the implementation of these procedural rights in Albanian law. And then Jordan, in the practice, has said that he's really in a chaos as a lawyer. I'm also a lawyer. I want to express my solidarity with him, because it must be very hard to be a defense lawyer in such a system, as he said with very strong words, a failed rule of law state. So when we come now to more my action as a lawyer here in Brussels, for example, when I see a client that has to be sent to this system, to Albania, I really try to resist the extradition demands because I see this really threefold problem: corruption, laws that are not in line with fundamental rights, and a practice that is horrible. And then what we try to do, we try to find reports. That's how we work, you know. And we know there are many reports. And I found out the last report I have, which is from the Venice Commission, from the Council of Europe, stating that there is a systemic problem of fair trial in Albania. It's a report from 19 June 2020 on paragraph 87. Albania is violating systematically the right to benefit for a fair trial. So when I have this document from an organization, which is an official organization, it's not an NGO like we can have, it's really like official position from a governmental organization, then this would lead the courts to stop the extradition, to stop any extradition to Albania, waiting for the system to be reformed. And it's a bit the same situation within the EU, as I said. You really have to demonstrate that there is, as the court said in the, and I said the Court of Justice in the LM case, very famous from 2018, where there must be serious reasons, objective reasons, reliable reasons, precise reasons to consider that there is a risk of violation of fundamental rights that would hamper extradition to another country. And this is implemented. For example, we have this decision from 7 January 2021 from the Court of Appeal of Brussels in the Catalan case, which is something quite important because it's the relationship between Belgium and Spain. And also we demonstrated on the basis of reports, of same kind of reports as the reports of the Venice Commission. In the Catalan case, it was opinions from the United Nations Working Group on Arbitrary Detention on the situation of the Catalans in Spain. And so the court came to the conclusion, the Brussels court, that there are serious reasons to believe that the person, in the case the Catalan leaders that are in exile in Belgium, that they would face an unfair trial in Spain. So this is really, we have to look, of course, not only in the implementation, the legal implementation of the directives. That's something we can look for some arguments in there, but also in the practice, and that's the more important. That's what Jordan said, the practice that shows really that even if there are some laws that are acceptable, that are that have implemented the 6 directives that Laura has been mentioning, it's a broader assessment. It's really an assessment towards, as you said earlier, also this case law of the European Court of Human Rights. And of course, when you see all the package of the case law of Strasbourg against Albania, and when you see the package of reports on the unfair trial, systematic problems in Albania, then you come as a lawyer to the conclusion that there is no cooperation more possible with Albania. So we are in the situation now where decisions are coming to and extraditions are stopped. So my question is, so what do we do? Can we do something about that? Because of course we need to go forward in this integration of Albania in the European Union, but we seem to be, I think, in a dead end. There should be some solutions, but I don't see which solutions at the moment. One solution could be that, for example, if you know this, you have this principle in international law, if you don't extradite, that you judge yourself. So, for example, aut dedere aut judicare, to express myself in my best Latin, is just like you extradite or you judge yourself. And so that could be a solution that I would say EU member state would then say to Albania, okay, you are in a process. I see that there are some progress, but I will not cooperate. I will not send you people because you will submit those people to an unfair trial, but please send me the case and I will judge the case myself. This is happening. This is, I think, quite, wouldn't say usual business, but it's something quite normal in international relations that a state refusing extradition would judge the person itself. That's my first remarks.
Thanks very much, Christophe. I'm sure kind of like, you know, given that you've been working on kind of Albanian extradition cases, kind of what Jordan said about kind of the country being a failed rule of law state would have kind of been quite alarming. But you kind of also said that these are kind of like, from an extradition practitioner's point of view, they're not really problems that are kind of absent within the European Union itself. And so kind of like, what do you see as the implications of, let's say, kind of the Albania joining the European Union and becoming part of the EAW framework without, you know, in sort of like a premature fashion with, especially with these, you know, the standards and the directives not being properly implemented?
Yeah, the thing is, according to the case law of Luxembourg, it's very strict because there is mutual confidence between EU member states. And it's a high level of confidence as stated by the court in Luxembourg, also in this decision of the Court of Appeal of Brussels of January 2021, the Court of Appeal says that there's a presumption of respect of fundamental rights between EU member states. And so it means that really it's a high level of, you have really to demonstrate a general problem and then a specific problem in a particular case. You know, if we refer now, no, there are a lot of problems in Europe. I mean, in Belgium, there are problems of fair trial. In Poland, there are specific problems of fair trial that could be more systemic. But then you always have to show in a particular case that there is, that this risk of violation of the fair trial, not only systematic is, for example, in Albania, because you don't have the transposition of the directive or effective transposition of directive, but also in the individual case you are defending, you are resisting the extradition, you have to show in that individual cases that there are serious reasons to believe, apart from systemic question of that the fundamental rights will be infringed. So it's very high level of confidence, which leads that EAW remains the rule, and implementation of the European arrest warrant remains the rule, but there are some exceptions. We can also refer to what happens with Romania at this moment, with the situation of the prison in Romania, where there is systematic violation of Article 3 of the European Convention of Human Rights, you know, a prohibition of torture, of inhuman treatment. And as there is this case load in Strasbourg about showing that there are so many problems, systemic problems in Romania, then there's the practice now is that there is no more extradition to Romania because of this problem. The specific thing about this cooperation in the EU is this individualization. What does it mean? It means that, for example, if you have a systemic problem like in Romania about prison conditions, then you have to tell to the judge, okay, you have to ask to Romania in this individual case where which prison it will be, etc. So you really have always to, that's the theory, but in practice, for example, about the Romanian cases now, the decisions in Brussels Court of Appeal is now to stop any demand from Romania, because they consider this systemic problem is enough, and that you don't even have to go to this individualization. In the Albanian situation, now we just begin to have some people begin to realize what the real problems are with Albania. There still is this demand of individualization of the cases, but the prospect, if the situation doesn't change in a few months or 6 months, 1 year, this will not be the case anymore, and the judges will stop any cooperation with Albania, even not looking in individual cases, because there is so many evidence of systematic problems.
Thanks, Christophe. I'm going to go back to law now. And I mean, I think I know the whole kind of purpose of these discussions is around, you know, kind of what Albania needs to do and kind of the impact of Albania's non-implementation of the directives, both on its accession process into the European Union and kind of the implications as to what happens if they join the EU without implementing these standards properly. But it hasn't exactly been plain sailing in the EU as well. And Christophe mentioned that, you know, even within the EU, you get lots of cases where EAWs need to be challenged on the basis of fundamental rights grounds. So I just wanted to get from you, Laure, very briefly, kind of like what the experience of implementing these standards have been in the European Union, and also maybe kind of reflect on what Irene said about kind of the gaps between standards and local laws. And see, you know, to see kind of, does that kind of ring true for, you know, existing member states as well in terms of their implementation of the directives?
Thank you, Bruno. Yes, absolutely. I mean, the fact that the EU has recognized as a key priority human rights and criminal justice in accession negotiations with Albania shows how important the implementation of the directives is, provided, as everyone has said, that we put the person concerned by criminal procedure at the heart of it. And this remains an issue when we talk about the difference between law and practice in all of the existing member states. And there's a lot to learn from these challenges that the existing member states have faced and continue to face. And a few successes, though, as well, in the implementation of the standards. So I think just Goran's statements first echoed as well to me the resistance in some member states where it was felt that the standards that the directives bring are already there. They're already part of the European Convention on Human Rights that all the member states are part of. They're already part in many domestic, most if not all domestic constitutions. But the EU standards do seek to involve something more. They are intended to go beyond the European Convention of Human Rights. And I was encouraged to hear that Irene spoke about improvement. Jordan did also speak about lack of rights in pretrial detention proceedings, and there you really touched upon the key huge gap in the EU legal framework. It's pretrial detention, which is a very grave concern because it's not only in Albania, it's in many member states that we see huge proportion of our prison populations, including here in Belgium, are made up of pretrial detainees, with in some cases no maximum duration of this pretrial detention, and this is not regulated by EU standards. Jordan also mentioned the use of glass boxes, something that we see in France, for instance, and where, thanks to the presumption of innocence directive brought in by the EU, groups of activist lawyers have really sought through concerted action to challenge systematically the use of glass boxes in courts. Now, that doesn't mean that the glass boxes have been removed thanks to EU law, but there is a standard, a concrete standard that lawyers can use to resist this practice. But going back to existing standards, the definitely implementation we see is not a one-off exercise. It's not one that only involves translating, a legal change on paper. That legal transposition means a job done. It requires ongoing work and support at all levels, from law to implementing rules and regulations and administrative circulars, for instance, that give guidance to prosecutors or police, to practice and also to culture and also to budget, to states making the budgets available, for instance, for legal aid. And implementation requires participation by all the stakeholders involved. It's not just about parliaments and governments, it's about also lawyers mobilizing these EU law instruments, about judges accepting to apply them. We still see a lot of resistance by national courts across Europe to use and apply these EU law standards. Prosecutors as well, of course, and police. So there's really a collective effort that's required to translate these legal standards into practice. And the European Commission does recognize it when it conducts implementation assessments. So years after the deadline for transposition of directives, it continues to conduct assessments of how these different standards have been implemented. And it's trying to recognize that there is a gap between the law and practice. It's not just about checking that member states have implemented the law, it's also about checking what the practice is around implementation. And we see in the different implementation reports that the European Commission has produced on at least the first 3 directives, so interpretation, information, and access to lawyer, that there are still some very grave implementation challenges in the existing member states. Now, of course, the European Commission can initiate infringement proceedings, but we haven't seen any to date. The European Court in Luxembourg is also key to try to promote implementation. And there's also finance from the European Commission, financing member states, but also financing civil society organizations like us to promote this culture change or to support training initiatives, for instance. But to be a bit more maybe concrete and go to an example that was raised by Irene as well, looking at access to lawyer and police custody. So access to lawyer in police custody, meaning before the police interrogation when you're arrested, and also the presence of your lawyer during interrogation. When this EU law right was brought in, very few member states had provided for it, and it was a huge leap forward when it was adopted in 2013. And of course, it was spurred on by the Saldus case in the European Convention of Human Rights, which obviously binded the member states. But this was an opportunity for progress. And the EU set a standard that goes beyond the ECHR standards. For instance, it also provides for a right to an effective remedy where this right is violated. And we've doing an analysis of ECHR standards on remedies. They're very, very few. If it's not torture, there's very little case law or guidance from the ECHR on what remedies should look like when there's a violation of fair trial rights. And even if you have a finding of violation by the ECHR, there's a lot of work still to translate that into changes in practice. We see it, for instance, in Belgium, where we have, in many of our prisons, absolutely appalling prison conditions. I do prison monitoring here in a prison in Brussels. And the gap between ECHR standards and rulings with respect to the Belgian prison conditions and the reality is massive. So it's not enough to have ECHR standards. And so to go back to, to access to lawyer, it's absolutely key, obviously, because early access can have a transformative effect on the whole criminal procedure. And rule of law really starts there. It starts with getting lawyers into police custody to prevent any abuse of state power and to keep law enforcement in check, to make sure that they remain within their legal mandate, within the remit of their legal powers. So member states were asked to put a mechanism in place to enable suspect to contact a lawyer. Many have. Belgium, for instance, introduced an online database called Saldus Web of names and contact details of lawyers, and that really required the cooperation of bar associations, police authorities, and prosecutors to communicate effectively to identify a lawyer very quickly, normally within 2 hours after arrest. And at the start, there was a huge increase in the number of people who were represented by lawyers, with some regions in Belgium meeting up to 90% of people arrested had a contact with a lawyer. And this right was extended, thanks to EU law, to all suspects. Now, we don't have more recent figures, and there have been since some legal reforms that may have watered down this right. So we're not quite sure I can pitch it as a success story, but it was originally. And then we see in some other member states where, as Irene pointed out in Albania, are facing huge difficulties, even in implementing an adequate system to facilitate early access to legal assistance. So for instance, in Poland, although formally in law, any detained person has the right to contact a lawyer, so that box is ticked, there are no legal provisions in practice that require police officers to make a list available at police stations or to set up a system. So it means that if you don't have, when you're arrested, a lawyer's name and number in your back pocket, you're not going to be able to get one. And then in other member states, we've seen as well that in some cases, when it comes to implementation, there have been avoidance tactics. So for instance, in Bulgaria, the concept of suspect was interpreted in a way that the scope of the directive was limited and excluded from the initial 24 hours of police custody, which was considered to be an administrative procedure, not a criminal procedure, which meant that the police could interrogate, question for 24 hours without any legal assistance being afforded. But then, in contrast to Bulgaria, we have a good example from Croatia, for instance, where just as in Bulgaria, the system didn't recognize this stage of police investigation as part of the criminal proceedings and treated it also as being administrative. And that was because it was considered it necessary for the police to be free to act to resolve crimes. And courts didn't have any supervision over what happened during this time. But thanks to the requirement to implement the roadmap directives, that led to real change in law and practice and made police detention an integral part of the criminal procedures and therefore under court oversight. So another success story with implementation, rising the standards. And I think that, yeah, I mean, the implementation challenges faced by Albania are far from being unique, but these standards set by the directives really give us a chance to improve fairness of criminal proceedings, and it definitely requires a collective effort to translate them into practice. And the fact that Albania shares many of its challenges with other EU member states really shows that there are a lot of benefits to sharing experiences and to continuing dialogue between activists in different jurisdictions.
Thanks very much, Laure. I think one of the most interesting things if you read the report that we produced, is, I mean, if you're familiar with this topic, is that in many ways it looks a little bit like a microcosm of all the, many of the challenges that we see in terms of implementation in other EU member states. So anything from this question, like you mentioned in Bulgaria, of kind of suspects not being treated as suspects at the initial stages of the criminal process. The issues around kind of, lack of funding of legal aid and the complexity in the funding of legal aid that disincentivizes individuals from accessing legal assistance at crucial stages of the criminal justice process. Also issues like, faulty letters of rights, issues like kind of lack of quality control in interpretation and translation, use of kind of restraints and cages and courts, and a lot of this stuff is just kind of a lot of the stuff that we see in other member countries is kind of also seen in Albania, which I thought was very interesting, and also why I think in Albania's context it's particularly useful and informative for there to be this kind of dialogue between a cross-jurisdictional dialogue in terms of kind of sharing of experiences and challenges, and potentially solutions as well, as few and far between as they might be in it may seem. But the other kind of interesting point that you mentioned there is the importance of implementation as being a collective effort and not just something that is affected by kind of legal changes, but also kind of interventions and activism from prosecutors, judges, and other competent authorities. The folks that are often left out in that conversation are kind of lawyers and, to a large degree, civil society organizations. I mean, obviously kind of there's a decent amount of recognition that lawyers are crucial in terms of implementation, but in Goran, I mean, in your case, I mean, you've been leading efforts in Albania as part of this project of kind of incentivizing civil society in the implementation of these standards and to do advocacy around the need to improve criminal justice standards. So I just wanted to hear from you kind of, as a closing, really kind of like, what you think is the role of civil society in all of this, and just give us a rundown of what you guys have been up to in Albania.
It's really tricky when it comes to role of civil society in improvement of rule of law in particular country, in any country in the world. So if you start from some other areas like media, so if you want to improve media freedoms in one country, and of course if it's not too repressive like North Korea, so you come there, and if you cannot help, I don't know, public broadcaster or media that are controlled by the state, you will help establishing of some portal or some alternative media in order to provide citizens alternative sources of information, alternative access to information. So it's quite simple, and you will have journalists to be safe and to have their work, even if they are working outside the country. So it's kind of simple in one way. When it comes to discrimination, to help like discriminated groups, you will come to the state, and if they are in the situation like Balkan countries, when you have some anti-discrimination framework that is.
We lost you.
Some European countries, so you will help. Sorry. I say discrimination, you will help most discriminated groups. You will strengthen the community, different communities, people with disabilities, women, LGBT, and so on. But when it comes to rule of law, it's really tricky, because the state is responsible for implementation of fair trial standard. There is only one judicial system, and if it's not working, you cannot, as a civil society, have something alternative. What you can do in one country, first of all, is maybe to help civil society organizations who are providing legal aid. We did that in Albania for a long, long time. And, but still, I'm always joking with, comparing with Belarus. In Belarus, if you have legal aid providers, but for 10 years or 20 years, they never have successful case. They never have. They have a lot of cases before the court, but they never have judgments that provide justice to victims that are beaten or something like that. I'm not saying that Balkan countries and Albania are like Belarus, but I'm saying that it's not dependent on civil society. So you are supporting that things, but you are very limited. So the second possibility that we have on table and that we are also doing in Albania is supporting monitoring. And we are doing that together with you, and some advocacy. So you advocate adoption of some legislation, you advocate some changes when it comes to implementation, and monitoring. You are trying to say what's wrong and telling government what's wrong and how they should change that. But the problem is everything at the end depends on government. You can have pressure from civil society, but that's not sufficient. That everything depends at the end on them. And the third pillar that we did once upon a time, we did a lot. This is a capacity building. Capacity building of different lawyers. So we are still doing capacity building of lawyers that are working in the human rights organizations, that are lawyers that are barristers, that are member of bar association, or so on. And once upon a time, we did a lot of capacity building of judges, of prosecutors, of lawyers working in ombudsman, in commissioner for equality, and many, many more. However, this situation changed over the time because we have judicial academies in all Balkan countries, and they should take care of judges and not us in civil society. However, we are still, because it's not sufficient and it's not works very well, we are, or academies don't have capacity sometimes in some cases. We are doing a lot of capacity building still. We are still inviting judges and so on. We have a big rule of law forum, and we put one topic, bringing judges from Strasbourg, and then they are for 2 days talking to judges in the region about newest jurisprudence of European Court. Because the fact is that lawyers in the region, they are not reading enough. Not all of them, I'm not generalizing, but let's say majority of lawyers, they don't have time to read, or maybe some of them are not speaking English very well, or judgments are very long, and many, many more. So we are trying to raise capacities, and we are trying to have them, to have a regional approach, to have all lawyers together, different lawyers, even judges, in order to exchange, information and to learn from each other when it's possible. We are trying to have some coalitions that are working on that advocate on procedural rights, on respect of some standards, and so on. So this is actually the framework that we have, and this is what we can do in any country, but especially in Balkan countries since they are quite close to EU. And don't forget why we are limited in Balkan more than in other countries. This is because donors will simply say, well, this is not a role of civil society anymore. To learn judges, well, that's a role of Judicial Academy. That's not your role anymore. And that project is not interesting for us anymore. So situation is kind of, I must say, complicated when it comes to rule of law. And we are doing as much as possible. And we will continue definitely working in all Balkan countries until a session is happening. But the problem will be also what will happen after a session, as we can see in many countries in Europe, like in, Poland or Hungary or Croatia, even to some extent, not too much, but let's say there is a need to invest more after that. And I think we will definitely stay in this region.
Thank you very much. I mean, I think it's a slightly depressing note to end on. I think we call this event a roadmap to the EU, but the road doesn't really end there. As we've especially seen in the last couple of years, we definitely know for certain that the road doesn't end here. And it is really a continuous process of ensuring that member states continue to adhere to fundamental rights standards and the rule of law. It's something that really can't be taken for granted. So it seems perverse to look at this as membership as the end goal. It's in a way, membership is just the beginning of another chapter in a country's journey. But I'm afraid to say, as interesting these discussions have been, we're now out of time, and I must allow everyone to go off and have their lunch. Thank you very much to Laure, to Goran, Irene, Christophe, and Jordan for your really thoughtful, very interesting observations and interventions. There's a lot of food for thought there, and it kind of highlights the complexities of the topic that we're discussing, and the need for longer term engagement in the country's criminal justice system, whether it is inside or outside the European Union. And I think we've given a lot of food for thought for people in the EU institutions as well, about the kind of things that they should be looking out for, not just in terms of kind of, you know, when they're looking at Albania's accession to the Union, but also maybe to encourage a little bit more of inward reflection as well, in terms of what's happening within member states and what else needs to be done. So on that note, I'd like to bring the session to a close. Oh, I also need to thank the interpreters as well, Amarilda and Ermali, for doing a stellar job with providing simultaneous interpretation. But yes, thank you very much, everyone, for joining today, and have a lovely afternoon. Bye.
Thank you so much.